All right. Well, I'm just conscious of time, so I will get us started because we are in a lunch break, and I'm conscious that some of you may be on a work lunch break too. So, hello and welcome, everyone. Thank you for joining us today. My name's Yuka, and I'm one of the support services officers here at Down Syndrome and Intellectual Disability Queensland. Firstly, we'd like to start by acknowledging the First Nations people as the traditional custodians of the land we are on today, and we recognise their continuing connection to land, water, and culture. We acknowledge the Yagara and Turrbal people as the traditional custodians of Meanjin, the lands on which our office is located, and we pay our respect to all elders past, present, and emerging. We're very grateful that you have all made the time to jump onto our lunchtime webinar today, where we will be discussing key legal considerations for individuals with an intellectual disability. This is an area of significant importance and one which we frequently get inquiries on when people contact the support services team. So we trust that this session will provide you with some valuable insights and information. Before we start the webinar, we just wanted to cover off on some housekeeping. So today's webinar is going to be recorded if technology does not fail us. And we will send the recording to everyone, excuse me, within a week of the session. So we will keep you posted about that. All participants have been automatically muted just to ensure the smooth running of this session. If you do have any questions during the presentation, we do ask that you type them into the Q&A box, which you should be able to see at the bottom of your screen, and we'll address as many of those questions as we can during the Q&A session at the end. If you do experience any sort of technical difficulties, please feel free to put that in the chat box at the bottom as well, and we'll make sure that we can assist as best as we can. If you're after live captions, we also have that available as well. So if you just click the CC or the show captions button at the bottom of your toolbar as well, they'll come up for you if you require those. So we thank you for your cooperation in ensuring to keep this session running smoothly. So it is now my pleasure to introduce today's speaker, Annelie Hovler, who is the Principal Solicitor and founder of Fawcetti Law and Fawcetti Disability Law. Annelie has many years' experience as a solicitor working with families where a family member with a disability needs special consideration, in particular when it comes to drafting wills, providing for a beneficiary with a disability, advising on enduring powers of attorney and guardianship documents, assisting with QCAT applications and procedures, as well as advising on special disability trusts and other trusts as well. In dedicating her career to supporting families living with a disability with future planning strategies through meticulous planning and thoughtful consideration, Annelie has become an expert in her field. So without further ado, I'm delighted to hand over to our speaker, and please join me in warmly welcoming Annelie. Thank you, Annelie.
Thanks, Yuka, and thanks for inviting me. Again, hello, everybody. Thanks for logging in today and taking your lunch break to spend some time with us. I'm going to talk to you today about the future planning, and I'm going to just share my screen so you don't have to look at my face the whole time. Now, how do I do that? Let's see. Share screen, it says. Yuka or Isabel, it seems like it's been inactivated, the screen sharing. Would you be able to allow me to do that, please? While we're sorting that out. Failing to plan for the future is a plan to fail, is what we say. And I mean, that's true in many instances in life. So one of the reasons that we're talking about future planning is obviously certainty, and get some certainty. In particular, when you've got a family member who's a dependent, it becomes extra hard for parents to consider what happens when I am too old to look after the person that's relying on me. Who's going to do it, and how we're going to do it? And, you know, no matter where your children are at, you're always going to be a little bit concerned with who can look after their finances for them. If you've been doing that your whole life, who's going to do that when you get too old, frail, or pass away to do it for them? These are all things that we talk about when it comes to future planning. we want to protect all of our family members, not just the dependents, obviously. So, you know, there's lots of reasons why you would consider your kids might not be capable of looking after a big inheritance. Either they're too young and inexperienced. You might have a child who's plain irresponsible and can't hold down a job, and you go, what's going to happen when I die? And they inherit $500,000. Or you might have somebody with an intellectual disability who simply can't inherit that sort of money and be expected to hang on to it for their own benefit and not having somebody take advantage of them. So that's the things that I'd like to talk to you about today. We're going to go through and talk a little bit about statutory guardianship and what that is. We're going to talk about enduring powers of attorney and QCAT. We'll talk about wills. We'll touch a little bit on special disability trusts and trusts in general, because I've had some questions in that regard. And we'll talk about capacity. So while the girls are trying to sort out my screen sharing permissions.
Annelie, if you can just try sharing again.
There it is. It looks like it might be allowing me to do that now.
Fantastic. Oh, wonderful.
There we go. All right, now I'm just going to make it a little bit bigger so you don't have to look at my mug the whole time. How do we do that? Slides. No. Help.
And Annelie, if you click at the bottom of that window, there is a little icon. Yes. Yep,
Down
that
here.
one. Yep, that's the one.
Or maybe not.
The one next to the Zoom, it looks like a little projector. If you go to the left.
Is it this one here that I'm pointing to now?
Yep, that's the one. If you click that one.
This one?
Yep.
Yeah.
Oh, no, sorry. If further down towards the minus end of that Zoom button, there is a little projector screen. So it's the, oh, sorry. It is the the fourth one after display settings at the bottom.
Slide to current window, the fourth one,
Oh,
this
yep,
little one.
yes, that one, yep.
Oh, look at you, you're a genius.
There we go. We're on the, I think we're on the last slide, but if you just want to go back to the first slide, it's working for us now.
We're on the last slide. Let's go to the first slide. There we go. We'll go.
Perfect.
There we go. Okay. So thank you so much for bearing with me with all of that. And I'm sorry I'm not 100% up to date with all this. That's the amusement part of today's presentation, is watching me struggle with my PowerPoint. Sorry about that, everybody, and thanks for your patience. Okay, so a little bit about what we'll go through. I talked to you about that already. The guardianship, enjoying powers of attorney and the powers they possess. We'll talk about the capacity. My cat, your cat, and QCAT. There's cats in every state, QCAT, VCAT, NCAT, depending on which state and territory you're in. So that's why we've got all these cats. But because we're based in Queensland, we're going to talk about QCAT. But if you're logging in from another state, there will be a cat in your state and territory as well. We're going to talk a little bit about wills, and we're going to look at trusts and what exactly are they and what can we do with them. So with no further ado, if we hop on to the statutory guardianship, and this is probably an area that raises a lot of questions, and people have got a lot of frustration around understanding how statutory guardianship works. What it is statutory is something that's set down in law. Anything that's set down in law is statutory. It's a rule, it's a law, it's there. With statutory guardianship, when we become parents, we are the legal guardians of our own children unless somebody proves otherwise, and that would take a court order to take that away from you. When your child turns 18, they are The law says that everybody over 18 has got legal capacity to make decisions for themselves. And if they don't, we have to prove otherwise. So by default, the law will just assume that everybody over 18 has got capacity, and then it's up to us to prove the other if that's not the case. So that's the hurdles that a lot of parents stumble across when your child turns 18. You know, some people find that bank accounts have been blocked, they can't talk to NDIS anymore, Centrelink won't speak to them. It's like a door's been slammed shut, and they go like, I am still Johnny's parent, like nothing's changed, he simply had a birthday, that's all. But this is what the law says, and this is what people around you in authority in their employment have to abide by. Statutory guardianship allows me, let's pretend I work at the bank and you've been coming in with your child since, you know, they were a teenager, they got their first Dolomite savings account, and you've been helping them with their banking all along. Your child's turned 18, you're still coming into the bank, and I'm still helping you with your child's banking, even though that child is now 22, 23 years old. What that means is that in my role as the banker here, I am relying on the law of statutory guardianship to make the decision that I accept that you are this child's statutory guardian, and therefore I will speak to you on behalf of your child. Now, the problem with statutory guardianship is that it's in the eyes of the beholder. And what I mean with that is that it's for me to grant you that title. It's for me to decide that I will accept that you are the guardian of this child, and I will rely on the law allowing me to make that assessment. And this is where parents get really frustrated, because you might go into the bank one week and the person there is ever so helpful and you get everything done you want. And then the next week you come in, or you might go to Centrelink next, and you're going to have a door slammed in your face and people going, I don't know who you are. I don't accept that you are this child's guardian. Prove it. And that's the problem with statutory guardianship. It's not that people are trying to be difficult. It's just that it's in the eyes of the beholder. And as you can imagine, if you are seeing somebody in authority at the Centrelink or the bank or your doctor's surgery that you have been dealing with for many years, and they know you and your child, it's going to be a lot easier for that person to grant you the statutory guardianship title. Whereas if there's a new staff member, or you move to a new town, or you change doctors, they don't know you from anyone, and they're going to question your authority, and they've got every right to do so. So the problem with statutory guardianship is that you can't force somebody to take that opinion. You have to just accept that some people will, some people won't. And obviously some workplaces will have rules in place for their staff and say, you know, that we do not grant our staff the right to consider a customer to be a guardian, or have that status. That's not for you to decide as the bank teller. The bank manager might have that power, but the bank teller doesn't. So you'll see where the friction arises and where people are getting frustrations. For some reason, we're finding that the pushback from authorities usually happen when the kids are late 20s, early 30s. Everything's been working smoothly until then. And then we find that we're starting getting more and more pushback, and it's frustrating. And you go like, why are people all of a sudden being difficult? My theory is that when your child reaches that age, a lot of the people you've been dealing with start to retire and new staff are coming on board, and they don't know you. So there's a lot of that. And also, as you would have heard, there's been a lot of misuse of these powers, abuse of people that are vulnerable in vulnerable positions, and authorities have had to clamp down and really demand to know who is the guardian and who's got the legal right to speak on behalf of this person or operate their bank accounts or whatever it might be. Another little issue that we find is obviously to the level of impairment causes a grey area. If you've got a person with a severe intellectual impairment, it's a lot easier for the person that you're speaking to to accept that they don't have capacity and speak to you on their behalf. When you've got somebody who's got a mild intellectual impairment and they're in that grey area, it's harder for somebody who's only just met them or who's only just seen them over the counter for 5 minutes to come to the conclusion that this person does not have capacity to manage their own finances, for example. So that grey area also causes issues when you're dealing with people in authority. So I hope that that explanation of statutory guardianship, it's obviously not going to solve your problems, but it might explain some of the frustrations you're meeting in day-to-day life when your child becomes an adult and you're finding that some people are just difficult to deal with. They're not doing it on purpose to annoy you. It's just a really difficult area for anybody to navigate in the workplace, to make sure you do your job properly, to make sure that you're not inadvertently assisting somebody to take advantage of a person in a vulnerable position, and also that you're abiding by the rules of your employer and the law. So having said that, I'm hoping that that'll give you a little bit of background as to why you're facing these problems when you go out some days, and other days you may not. So moving into the enduring power of attorney, the enduring power of attorney is a legally binding document that allows somebody to appoint somebody else to be their attorney. Now, obviously, if you have no legal capacity at all, then you can't enter into a legally binding document and you can't give instructions for an enduring power of attorney. If you've got a mild intellectual disability, there's a possibility that you may have the capacity to understand what an enduring power of attorney is and give instructions for it. So again, case by case basis and client to client, we need to see who's got that capacity and who doesn't. A lot of my clients have got Down syndrome and have been able to give instructions for an enduring power of attorney. It's just, we have a simplified document, and we go through a little bit of a longer process to establish that the person does have that capacity to give that instruction and understand what they're doing, before we enter into the documents. But it's not a blanket rule that says that, just because you got Downs or some other kind of intellectual impairment, you're not even allowed to consider it. So case by case basis. And we'll talk about that more when we get on to the capacity side of it. I'll talk a little bit more about capacity in a minute. With an enduring power of attorney, you're putting somebody else in your shoes. We often think that the enduring power of attorney is only for old people in a nursing home with dementia, and their children can make decisions on their behalf, or their spouse can step up and speak on them. The enduring power of attorney is that, but it's also so much more. I've encouraged my children to create enduring powers of attorney before they went off to Europe and traveled around the world and got themselves in trouble there. And it's just a simplicity thing. One of my daughters had her motorhome broken into in Italy and lost passports and computers and everything else. With the enduring power of attorney that she had granted me that power before she went overseas, I was then able to go into the bank and block her credit cards and get new cards and talk to the travel insurance company and assist in getting new passports sent to them and things like that. So a really helpful document, if you appoint somebody you trust implicitly. So, and it also means that the capacity to act doesn't need to be permanent. It can be temporary. You go into a hospital for a simple surgery and some complications arise, and you need to be there for 2 or 3 weeks instead of half a day. With an enduring power of attorney, in the correct way, your family or your loved ones are then able to act on your behalf during that period of time. And then when you come good and you're back home again, there's no need for them to use it. So a useful document, very powerful document, but also a very useful document to have. And it's got lots and lots of options. You can appoint one person, you can appoint 4 people, you can appoint them to act together, or you can appoint them to act one at a time. You can appoint different people to look after your finances compared to who's going to look after your personal health care matters. So very, very flexible document that we can do lots of things with to make sure that you are protected for the future by people you trust implicitly in the best way possible. I touched on capacity previously, and we might talk a little bit more about that capacity. So as we said, capacity is not you either have it or you don't. It's flowing throughout your life. And you don't need to have a disability of any sort to have different levels of capacity. You know, I've got capacity to drive a car, but I don't have capacity to drive a semi-trailer. It's all different things. You know, I can run 5 kilometers. I can't run a marathon. Doesn't mean I can't ever run a marathon. It just means I can't do it today or tomorrow. So capacity is flowing and fleeting. Capacity is also depending on where you're at in life. If you've got a mental health condition, for example, there might be days of the week or a period of a couple of months when you're not at all capable of looking after your own personal hygiene, let alone your finances. And then you come good and you have a really good period. And that good period might be a couple of months, it might be a couple of years, and you're doing beautifully. And then things go downhill again. So capacity, we need to know, is not there or it's not. It can be very flowing and fleeting. When people make a will on their deathbed or in palliative care, we have to look at the lucid moments, which even within such a difficult period of your life or at the end of life stage, people often will have lucid moments. Or it might just be that, we can speak to them and have a good discussion before the next lot of medication, things like that. So yes, capacity is not a solid set in place thing, and it's not something that you either have or don't have. We have to assess it all the time and make sure that right now, today, you've got capacity to do whatever it is that we're talking about. And in this instance, obviously, it's legally binding documents, contracts, wills, enduring powers of attorney, that sort of thing. So that's what I'm talking about when I'm talking about capacity there. It's important to know that it's not just there or it's not. In some instances, it is very clear that, this person will never have capacity to look after their finances. And in other instances, you might have a child with Down syndrome in your care who's very capable of looking after their own pocket money, but certainly wouldn't be able to handle a share portfolio of $500,000. That's true for a lot of us. You don't need to have an intellectual impairment for that. So important to know that capacity can be different levels and different requirements before you can do certain things. And we move on to QCAT. So this is the My Cat, Your Cat, and QCAT. What is QCAT? And why do we need it? And when do we need it? And do we always need it? QCAT is designed to be a people's court. It's a simpler version of the magistrates, the districts, courts, and it's got powers to deal with certain things. And one of the things that it can deal with is the guardianship. If you find yourself in a position where your adult child is relying on you and dependent on you, and you are getting pushback from people in authority, people won't accept that you are your child's legal guardian. They refuse to speak to you. They won't let you operate the bank accounts. NDIS and Centrelink are demanding some sort of evidence that you have got the power to speak on behalf of your child. If your child does not have capacity to give you that power and enduring power of attorney, then we need to go to QCAT and ask them to help us set legal documents in place. And that's what QCAT can do for us. The processes of QCAT are meant to be simplified, and that's comparing it to the court system. So, the language within QCAT is less formal. The forms are less formal. The language you can use when you speak to QCAT is less formal than a court. The costs are lower than court applications often. And it's meant to be a solicitor-free zone. Having said that, I do go to QCAT on behalf of clients sometimes, but I always need QCAT's permission to represent a client, and I need to have an excuse of why that client needs a solicitor in their corner. Sometimes I just go along as support in the background, and the client will attend to QCAT themselves, and I'm just there for them to turn to when they've got questions or in between sessions and things like that. So I don't actually speak up on their behalf. They represent themselves, but I can be there in the background. And sometimes it's enough that people come to me with their QCAT applications and say, this is what I've prepared. Is this enough? What else do I need to do? What can I expect? And we'll go through it all and talk about the processes, and then they're still off to QCAT by themselves. So all sorts of levels there. You're all familiar with wads and wads of paper from different authorities, NDAS, Centrelink, that sort of thing. Unfortunately, QCAT is no different. There's going to be more wads of paper when you go to QCAT. And it's frustrating, but it's not necessarily difficult. They're not complicated, but they're voluminous. So, if you could just wrap your head around the fact that, yep, we're going to go through the QCAT application, we're going to do the documents as well as we can, we're going to get through it. It's meant to be a simpler process. Most of my clients that come to see me and need help with QCAT, and that's not obviously the people that go through QCAT themselves, they don't ring me and tell me that they've done it and everything's gone well. So I only speak to the people that need the help or stumble a little bit on the requirements and on the line. What I find as a theme with everybody is that probably the biggest hurdle is for a parent to be put in a position where they have to go to court and prove their worth and ask permission to be able to act for their parent. Mentally, it's a really difficult step to take. And it's humiliating, maybe not the right word, but emotionally, it's a really difficult process to go through. So if you can get over that mental hurdle and accept that, because people have been taken advantage of, because vulnerable people have been mistreated in the past in droves, that's why QCAT and other authorities have had to clamp down for the protection of the vulnerable person. It's not an attack on you as a parent. If you can sort of get that wrapped around your head, I think the process becomes a little bit easier to deal with. But yes, it is a bit of a mental challenge as well. I've popped the link to QCAT in the slide there. If you wanted to have a check, you'll find that QCAT provides a lot of information in plain English, and there's little videos of what to expect when you get there. There's step-by-step assistance to go through the documents, and you can have a look at it if you get to that stage in life where you're having pushback and people are asking you to prove that you have the right to act on behalf of your child. Just mention really quickly too, I refer to parents and children throughout this speech. That doesn't mean that I assume that everybody's a parent and everybody's a child. It's just for simplicity. I acknowledge that among all the people that I call parents, there will be grandparents and there will be other relatives or siblings, aunties and uncles, or foster parents that are stepping up and acting as guardians. And with children, I include anybody vulnerable. So whether you're looking after an elderly parent or a sibling with a disability, or it is an adult child, I'm just going to call them all children for the sake of simplicity here in this presentation. But the rules are the same that apply to you, regardless of which position you're in. Obviously, if you're the sibling or a grandparent or a step parent, you're going to have pushback faster than if you are the parent in a lot of cases. So that's just with the terminology there. I imagine there'll be a few questions. I can see a few things popping up in the chat there. So I'm just going to move on and ask that we do all the questions at the end, if that's okay with you. I think that's less interruption that way. And you may find that some of your questions become answered as I move along. So we've talked about capacity. We've talked about statutory guardianship and what that is. We've talked about the enduring powers of attorney documents and QCAT, which is, so QCAT guardianship documents would be an alternative to enduring power of attorney documents. You only need to go to QCAT if the person that needs the help does not have capacity to make an enduring power of attorney themselves. And the next document when we're talking about future planning is obviously a will. A will and an enduring power of attorney will never work side by side. The enduring power of attorney looks after your affairs while you're still here, but not able to look after your affairs by yourself. The will looks after your estate once you're gone. So it's either one or the other. You're either here or you're not, and we either use the will or the enduring power of attorney. The two documents will never work side by side. It's one or the other. But obviously we create them side by side to make sure that we've got a good future plan and covering as many bases as we can. Having a will and enduring power of attorney in place is insurance. You know, you have insurance, you hope you're never going to need to use it, you hope the house is never going to burn down or the car's not going to be stolen, but you still insure them. Your will and enduring power of attorney are much the same. It's just that with the will, we know we're going to use it. It's death is inevitable. So, you know, we've got it there to make sure that the future is planned as much as possible. What happens if you don't have a will? There are laws for that too, because nobody is allowed to just vanish off this planet and leave their affairs in limbo. Things have to be wound up and finalized. So if you don't have a will, the laws of intestacy, which are the laws that cover what happens when somebody dies without a will step in, and your family will have to abide by those laws, whether they are practical or suitable for your family's circumstances or not. So in that instance, the laws of intestacy is very much one size fits all. And it's just too bad if your family doesn't fit that mold, because that's what the law says it is. And that's where a lot of families have, you know, you have problems with an estate, you have siblings suing each other, you've got to go to court to ask for permission to do certain things, or sell an asset, or keep an asset, or invest while you're waiting for the assets to come on, or continue to operate a business. If the person that died has got a business, are we allowed to operate it, and who can? That sort of thing. That they're all complications that arise if you don't have a will and you haven't left any legal power for your family to deal with those things. So the will is not for your benefit. You're dead, you're gone. The will is there for your loved ones, to make it easier for them to tidy up your affairs after you're gone. It's more beneficial for your solicitors if you don't have a will, or if you have a poorly drafted will, because solicitors make a lot of money when families start fighting over an estate. If you really love your family, I'd recommend you get a will and make sure that, you know, things are going to be as smooth as possible. Grief is difficult to deal with. Add money into that and a bit of family tensions, and you're leaving behind a difficult mess for your loved ones to sort. So in my opinion, and any solicitor you speak to, a will is very important in that regard. It ensures that your wishes are carried out the way you want and by the people you want, and it can protect all of your families. And I love the saying there, we can't rule from beyond the grave, but if you've got a well-planned estate plan, you can get pretty close. And yes, the cost of winding up an estate can be a lot smoother and easier sorted if you have a well-planned estate plan. A will, like everything else, when we deal with people, we're not all the same. They're not going to be one size fits all. It's not often a simple, we call them a love you will. And it's basically everything I've got, I give to my spouse. And if they have died before me, then my children get the lot. In its very simplest way, that's what it is. It needs to have the powers set out in it of what they can do with those things. If the estate contains the family home, for example, do they have the power to sell it, rent it out, own it together? Can one sibling buy the others out and keep it? That sort of thing. It all needs to be allowed in a legal document for your children to have the power to do those sorts of things. It might be that they want the house sold. However, the market right now is not excellent, but if we can rent it out and hang on to it for 2 or 3 years, we can get a much better price for it. Or if we can renovate the bathroom, then we can get a much better price for it. Are they allowed to do that? Well, that depends on the terms of the will. Does the executor have the power to do those sorts of things? If there's a business, there might even be more than one family member working in the business, and the business owner passes away. What happens to that asset? Is anybody allowed to continue to operate the business accounts? Is anybody allowed to sign contracts on behalf of the business? We need to know these things before you pass away so that we can smooth the way and make sure that things flow nicely for your family and loved ones before you go. And that's why future planning and will planning is so important. If you've got an adult child that is dependent on you for the rest of their life, as you can imagine, having all these wheels in motion before you go, ready to click in, is extra important. So that's one of the things that we talk about when we talk about future planning. I've added a little thing about trusts because I often get questions about trusts. So in the English dictionary, a trust is a firm belief in the reliability, truth, or ability of someone or something. Legally, a trust is an arrangement whereby a person holds property as a nominal owner for the good of one or more beneficiaries. Well, what does that mean? In its very simplest form, if I give Yilka $5 and ask her to grab me a coffee when she goes down to the coffee shop, we've created a trust. I've given her my money. I've entrusted her with it. She's now the trustee of that money. She's holding it as the nominal owner for my benefit. I'm the beneficiary. And, I have given her the power to use that money to buy the coffee. In its more complex forms, obviously, I could set rules around this. I could make the sum of money much larger, and I can add to the beneficiaries and say, you can hold $100,000 on behalf of me and my children, and you've got the power to invest that money on my behalf. The trustee would still not own that money, but they are only allowed to use it the way I've stipulated and for the benefit of the beneficiaries that I've stipulated. So that's what a trust is in its simplest form. There are lots of different types of trusts. You would have heard that some families will have, we've got a family trust. They're often set up to protect the assets of a family group from outside forces. It's a way of not putting all of your eggs in the one basket. If you put the investment property in a trust and you've got your family home in another, and the business that provides the income for the whole family is owned by another trust, then you've separated those eggs in one basket. If one basket falls, you're not going to lose it all, is the hope. If it's all set up correctly, then you can sort of limit the damage to that one asset that's held by that one trust and deal with those financial consequences while keeping the rest of it separate. If you've got money in super, your super fund is a trust. Now, if I ask a client how much money is in your super, they will often tell me, let's say $100,000 or $200,000. That's not money they have. That money belongs to the super fund until you pull it out. The super fund is holding it on your behalf, but you don't own it until you pull it out of the super fund and put it in your pocket. And that's how it sits protected and separately. And the same thing with the family trust. When we're talking about estate planning and future planning with our wills, we can create a testamentary trust in the will. That testamentary trust will consist of whatever inheritance you leave behind for the beneficiaries that you appoint in your will to be managed by the trustee that you appoint in your will on terms that you appoint in your will. So this is where it comes in, as I said earlier, you can sort of rule from beyond the grave. You can control what your family members can and can't do with the wealth you've accumulated through your hard work in your life that they will then inherit. You can make sure that your narky daughter-in-law can't just leave your son as soon as he gets the inheritance and take half of it with her and go off and form a new relationship. You can make sure that that inheritance stays in a trust and your son doesn't own it. He'd be a beneficiary or one of the beneficiaries of it, but it also protects it from things like that. If your daughter owns her own business and she gets an inheritance and the business goes bad or belly up, the inheritance sits in her bank account. It's part of her assets and it can be used to pay the people that she owed money to. Whereas if the inheritance sits in a trust, people can run her company bankrupt as much as they want, but they can't trust the inheritance. It belongs to the trust. It doesn't belong to her. So this is a reason why people will set up trusts, for one trust for their investment property, one trust for the business they own, and then keep their family assets separate again. A testamentary trust does not come into existence until you die. So you don't have to pay today to set up the trust. You don't have to pay every year from now until the date of your death to audit the trust. You don't have to find wealth to pop into that trust to keep it going. It doesn't come into existence until you pass away. And then it comes into existence on the terms that you have created to be run by the people you have appointed to benefit the people you have appointed and nobody else. And this is especially important when you've got a dependent who does not have capacity to look after their own finances. Their inheritance will be placed in trust on their behalf for their benefit to be managed by somebody else that you've appointed, that you trust implicitly. And also, if there is any money left of that inheritance in that testamentary trust when the beneficiary passes away, you have already in your will, many, many years before that happens, decided, well, who will inherit the leftovers if there's any money there. So if you've got 3 children and one's got a disability, the person with the disability would put their inheritance in there, and you can say, well, if they don't use up all that money before they pass away and there's any left over, then I want my grandchildren to receive that, or I want my other children to receive what's left over, or I want it to go into charity or whatever. But importantly, what you're doing is that you're not leaving somebody who does not have the legal capacity to give instructions for a will with assets. You're making sure that your inheritance goes to where you want it to go always. And that's the power of it. Testamentary trusts also have tax benefits and cost benefits that the other trusts do not. Because they are created by a will, they are afforded tax reliefs that, say, for example, your family discretionary trust or your self-managed super fund does not have. So there's lots of benefits. We often call a testamentary trust will a tax effective will. And having said that, you can see how it'll benefit not only the child with a disability, but all of your children, to protect the inheritance and the wealth you've created in your life from things like family breakdowns, divorces, businesses that go bad, or difficult times in life. So yeah, lots of benefits with those trusts that we bake into the will, but don't come into existence until after you've passed away. So again, it's not going to benefit you. You'll be gone. This is something you're doing for your loved ones and for your family after you're gone, to make sure that their life is as easy and smooth as possible, and also to ensure that the wealth that you've created throughout your life is going to benefit the people you love the most. So that's a very brief explanation of what trusts is. I did do a couple of terms at uni to get through all of it. But yeah, briefly, I think that explains trusts. We haven't touched on the special disability trust, and I'll mention that quickly before I move on. The special disability trust is a very specific creature. So we talked about how the trust, when you set it up, operates within the rules that you've created by the person you've appointed as a trustee for the benefit of the people you've appointed. A family discretionary trust or a testamentary trust have got pretty wide rules and a lot of room for you to make decisions about what you want to happen and what powers you want the trustee to have and to be able to do with that money. The special ability trust is a lot narrower. It's got a very specific scope. There's not much room for us to edit it without somebody or the court speaking up and saying, well, you've edited so much, it's no longer a special disability trust. You've just created another trust. I don't care what you call it. If it's not following the rules of a special disability trust, it's not anymore. So it's got a very narrow scope, and it's not necessarily the best vehicle all the time. And again, one size does not fit all. Sometimes it works perfectly. But it's not necessarily the case that just because you've got somebody with a disability in your life that that's the only thing you need to set up, or that that's the perfect and right thing for it. We need to check the circumstances and make sure that any trust that we create will have the power and the scope to do what it is you want it to do. And I imagine there'll be a few questions raised. I don't think I've answered all your questions with that, but I hope I haven't confused you more either. A lot of information to take in. And where's my arrow gone? There it is. In a short time. I'll try to summarize it. What do we do next? You've sat here and you've listened to me and been baffled by everything I've got to say and thought, oh my God, I need to get my affairs in order as soon as possible. Where do you start? What do you do? One thing you do is talk about it. Death is inevitable. It's going to happen. And, you know, insurance is something that happens in your life on a regular basis. Wills and enduring powers of attorney belong in there. They need to be in place for an appropriate future planning. Review your estate plan with your solicitor, and depending on how your financial circumstances are, you may have a financial planner, or you may need to get a financial planner if there's investment properties or there's separate families, if there's a business or a farm or something like that. You know, the more complex your finances are, the better the reason to go and get some financial advice on where do we go with all of this? How do I manage it best for my family now so that when I pass away, the inheritance is not going to just all disappear? We often sit down, solicitors, financial planners, and families together when we've got complex arrangements. And if it's a simpler arrangement, it's husband and wife, couple of kids, no children from any previous relationships, and you've got your family home, a bit of super, some savings in a bank account, perhaps some shares and a car or two, maybe a fishing boat, that sort of scenario, then it might be enough that it's just your solicitor and yourself discussing it, and we don't need to involve a financial planner. So again, one size does not fit all. We need to look at your family circumstances, talk about it, and review your current estate plan. Step number one. If you've got a person living with you who's dependent on you for their future well-bringing and looking after their wealth, you need to look at what you're leaving them with if something happens to you. If something happens to you next week, who's going to look after that person's personal health care? Where are they going to live? Who can manage their finances? Who can speak on their behalf? What do they need? We need to talk about all of those things. And that's an important part of what we do at Facility Disability Law. When we plan for the future, it's so much more than just the legal documents. We create that whole future plan with you, if you like. So that's the sort of thing that we can talk about. And again, if your dependent person has got capacity to give instructions for a will and enduring power of attorney, or do we need to go to QCAT to ask for those documents to be put in place? If you've already got QCAT documents, are they working for you? Is there a backup plan for what happens if you are the parents and you are responsible for this person? What happens when you can't anymore? Have you got a backup in place? What is in those documents to cover for that sort of thing? And it's also important to note that QCAT documents and orders are rarely permanent and indefinite. They usually last for 1, 3, or 5 years, and then they need to be reviewed or tweaked or asked to be renewed and things like that. So look at also how long ago did you get your QCAT orders? What are the terms? Do you have reporting duties? Are you fulfilling those? And is it time to renew or review soon? Now, I've given you an awful lot of information in a short period of time, and I hope I haven't put you off and scared you with all of that. I'm also mindful of the time that we're going. Have we got time for some questions and answers, Yuka and Isabel?
We might have 5 minutes, maybe.
5 minutes, yeah, all
Questions,
right.
yes. As expected, we did have a lot of questions come through on the chat and Q&A, Annelie. So I'm just wondering, we have collated those questions, so I'm wondering whether we could work through a few. And then I can see that you have shared your details there on the slide, so whether we can potentially share those details and people can get in touch with you directly.
Yeah, and if you want to send me those questions, I might just make another little recording and send it to you that you can share with people. We won't make it a webinar, I'll just do a recording and answer some of those questions separately if you like.
That'd be perfect. Thank you, Annelie.
Happy to.
Okay.
All right, and yeah, anybody else, you're always welcome to contact me. Check my website. These type of presentations that I've done for you today, I do them for not-for-profit organisations and special schools. If you want to book that in, that's on my website, or if you'd just like to check in with me for an appointment, you can find a link for that too on my website, or flick me an email. Happy to help if I can.
Wonderful.
And I hope I haven't scared you all with all this legal chat. I've tried to keep it simple. It's a lot of information to take on, and they're important topics to talk about. Yeah, sometimes you just got to grab the bull by the horn and get it done.
Absolutely. And I think it's one of those things that, like you said, it is really overwhelming to have to look into all of these things. And it is helpful to come to sessions like this to, and particularly when you've given those sort of next steps and sort of considering what it is that, family members need to do to ensure that all of these things are in place when they are no longer able to be there to support the person to make those decisions. I think it's really helpful to be able to think about those things. And think about them in advance. Very helpful.
Yeah, I mean, it's the biggest worry we've got as parents is who's going to look after our children if something happens to us. I don't think that's a worry that ever goes away.
Yeah, that's right. Okay, so I'm just wondering whether we could maybe just answer maybe one or two questions, Annelie, before we sort of pop off. And then, like I said, we will collate all the other questions that are still coming through and we'll send them to you. And if you wouldn't mind just responding to some of those questions, we can then send out that recording as well to everybody post this session. So one of the questions that we did have was, who determines capacity?
That's a really good question. So obviously, as parents, we've got a lot of power. And as I said, when we talk to a statutory guardian, then it's in the eyes of the beholder to determine that the person you're bringing in to the office does not have the capacity and that they are allowed to speak to you on your behalf. So that's the most informal way. When you go to QCAT and you're asking for guardianship orders, they will ask for a letter from one or more medical practitioners. So often with QCAT applications, when you're asking for guardianship of a person's health care, they will ask for a letter from a treating practitioner to say that they don't have capacity to look after their own personal health care and or finances or at all. There's often also a psychologist or psychiatrist report goes in with that saying much the same thing. Sometimes we need an occupational therapist added to the mix. So lots of people together present the evidence, and then ultimately QCAT will make the decision that, okay, we accept that this person does not have capacity and you can be their guardian. But yeah, the more information we can provide QCAT with to make an informed decision, the better, of course. But yeah, often it's the first step will be your GP that's been treating for a while.
And then the other question is, what if the child has a trust fund managed by another family member?
Yeah, so a trust, as we said, is a separate entity. And the trust is created to operate around the rules that's made that trust. So there is no one blanket rule of saying what happens. Those rules are set in the trust document itself. So if somebody has set up a trust for the benefit of your child and other children, it might be that the grandparents have set up a trust for the benefit of all of their grandchildren to be operated by an accountant that they trusted or an uncle or something like that. The trustee of the trust is the person that operates it. That person is bound by the rules of the trust. So you need to find out what the rules are to know what your rights are. If you have got the legal right to speak on behalf of a beneficiary, you could possibly ask questions, but often with a trust, it's discretionary on the trustee how they want to distribute that money, how they want to invest it, and when they do so. So it may well be that if your child is the beneficiary of a trust that somebody else manages, you might not have any right at all to demand any answers or money from that. It's often at the discretion of the trustee, but obviously we'd need to read the trust document before we know for sure who's responsible for what and which parameters they're allowed to operate within and what rights a beneficiary quite often a beneficiary have no rights at all. You know, you are a beneficiary of a trust. You have got the right to expect that you might get something, but you've got no right to demand. That's often the case. And again, unless the trust document says something different, you know, some trust documents might stipulate that all of my grandchildren will receive $1,000 on their birthday for the rest of the money left in this trust, something like that. Well, then you have a right. But quite often, a trust document will be at the discretion of the trustee. So yeah, we need to read the trust to know exactly what rights you would have in that position.
Amazing. Thank you. Um, I am conscious of time, so I might just leave it at that with the questions, and we will send those questions to you, Annelie. But just to wrap up, we just wanted to, on behalf of everyone here, we just wanted to thank you, Annelie, for joining us today and sharing your insights. Your presentation was incredibly valuable, and we really appreciate the time and effort that you've put into providing this information to our community. And thank you to all of you for coming today. Like we said, we will send out those recordings within the week, and we'll also share Annelie's details if you do have any further questions or wanted to connect in with Annelie. Otherwise, thank you so much for joining us on a Tuesday lunchtime, and we hope to see you at another webinar soon. So thank you.
Thank you. Thanks so much for inviting me. Thanks everybody for joining me. Bye.